What are the kids doing?
Eating toast and watching cartoons.
For the record, this paternity complaints is before the court on the plaintiff father's motion for temporary possession of the minor children. This hearing this morning is being conducted via Zoom. President Attorney Kimberly Kuhn representing the plaintiff father, Charles Redding. Mr. Redding appears to be present. In addition, the defendant mother, Chloe Lewis, appears to be present. Ms. Kuhn, before we begin, this is a paternity complaint as opposed to a custody complaint. Was there an acknowledgement of paternity signed by the parties?
Not on one child, Your Honor, but he's going to, the rec does deal with the one child that paternity wasn't established for. We're going to establish paternity for the youngest child today.
Okay, the parties both acknowledge paternity and the record. We don't need DNA testing, is that correct?
Correct.
Yes, Your Honor.
All right. The parties have conferred with Mr. Pratt in front of the court this morning. Mr. Pratt has provided the court with a fine recommendation with respect to the two minor children, ages 2 and 1. The parties shall share joint custody of the two children. Parenting time shall be reasonable and liberal. The parties shall work together and cooperate to ensure the mother has reasonable parenting time. The parties agree to engage in joint counseling. While this case is pending, the children should not be removed from the state of Michigan. Mother is seeking an adjournment so she can consult an attorney. Further, both parties agree that Charles, the plaintiff, is in fact the father of the minor child Miles. They're getting the birth certificate for the minor child Zara. And further, that this matter be continued to April 23rd, 2024, at 3 p.m. That's recommendation. Ms. Kuhn, is this recommendation agreeable with your client this morning?
Charles, is this recommendation agreeable with you?
Yes.
Yes, Your Honor.
Ms. Chloe, do you understand the recommendation?
Yes, I agree with all that.
Okay, do you have any objection to court adopting this recommendation?
No, not at the moment. I would like to consult a lawyer more first.
Certainly. And we'll come back on April 23rd at 3 o'clock. In the meantime, hopefully the two of you can work together. Obviously, the two children to see each parent as much as possible. Just you simply cannot remove the children from the state of Michigan until the court modifies that order. Is that understood?
Yes.
Yes, Your Honor.
Right. That applies to both parties. All right. So, but we need to take some testimony this morning with respect to the minor child Miles.
Charles, you have two children, correct?
Yes, that's
Two
correct.
biological children. And Zara, your daughter, you are on the birth certificate. So paternity was established for your daughter, correct?
Correct.
Is Miles your biological child?
Yes.
Is there any way that Miles cannot be your biological child from when he was conceived to when he was born?
No.
Were you in a relationship with Chloe Lewis?
Yes.
And it's your understanding that the two of you were in a relationship and that there could be no other possibility of Miles having any other father, correct?
That's correct.
And are you asking the court then, you are then swearing under oath that you are the biological father and you're asking the court to establish paternity with
Yes.
regard to Miles, correct?
Correct.
Okay.
Thank you. Ms. Lewis, did you hear the testimony this morning of Charles Redding?
Yes, I did.
Was this testimony true and accurate?
Regarding to this order, no, it wasn't.
Okay. The testimony this morning that he provided was that he's the biological father of the minor child.
Oh, I'm sorry. Yes, that is true.
Okay, he claims he's the father. Do you specifically admit and acknowledge that he is in fact the biological father of the minor child Miles?
Yes, I do.
All right, that was his own testimony this morning. Ms.
Okay.
Kuhn, do you have any questions of Ms. Lewis regarding this issue of paternity?
I don't, Your Honor.
Very well, based on the testimony that's been presented this morning, the court finds that the plaintiff, Charles Redding, is in fact the biological father of the minor child Miles. The paternity is established. Ms. Lewis, do you have any other questions this morning?
No, not right now.
Okay. Copy of this, the court will adopt this recommendation And then the card would encourage you. It's essential to the welfare of your children that they spend as much time with mom and dad as possible, and they don't sense any animosity or tension. So work together for their benefit. And there's no reason why children can't be overnight with mom, correct? I don't know what her living accommodations are, but I presume there's no reason why she should not have overnights with the children as long as she does not leave the state.
Your Honor, I don't think my client's opposed to that at all. I think the parties need to work out a parenting time schedule where they're both enjoying overnight parenting time. And I don't have any belief that mother's going to violate your court order and leave the state. Charles, you don't feel that she's going to take off, do you?
No,
Okay, Chloe, you're not going to take off. You're going to stay and adhere to court orders, correct?
Correct.
Okay. So yes, I think the parties need to work out a parenting time schedule where they're both enjoying parenting time with their children. And they're going to be going to counseling too, which I think is going to be really beneficial, Judge.
All right, the court would agree. And the sooner we unite mom with children, the better. And obviously, Miss Lewis, you do want to comply with this court order because obviously you could be charged with felony offense of parental kidnapping if you leave the state with the children. So I trust we're not going to go there. But we'll see you back on April 23rd. At 3 p.m. for further proceedings, and you'll be mailed a copy of this order. All right, that will conclude this hearing. You can all zoom out. Have a good rest of the day. Thank you. Defendant, I believe, wished to consult an attorney, and she has since brought on board Mr. Goldman. Parties have conferred with Ms. Patrick this afternoon. One moment, I'll share with you her recommendation. It is simply noted that the parties are currently residing together. So, due to the fact that the parties are living together, no need for any type of custody or parenting time order. Is that correct?
I disagree, Your Honor. The parties are not getting along. There have been threats made by Miss Lewis to leave the home. There have been threats made to get a plane ticket and go to Arizona. I don't want to be in the same position.
That is not true.
Where I am running back into court and asking for orders to prohibit a party from taking the children out of state. My client also said that the parties are not getting along, that there may be an eviction proceeding. So Ms. Lewis might be finding alternate housing because the parties aren't getting along. So yes, they're living in the same home. No, it's not going well. It behooves me. I can't comprehend why the parties won't agree to joint legal custody. My client right now doesn't have any rights to weigh in on medical. The kids are young, they don't go to school yet, but before we know it, that's going to be an issue. So really, if nothing's done, we're going to be back here in a month because things aren't going well. So yes, they're living together. No, it's not going well. There have been threats to go. So why wouldn't we agree to a joint legal custody, reserve parenting time until they've moved out and they're living separate and apart, and also have the standard language that the children are to remain in Michigan unless by further order of court. So I would really like to put the protections in place that aren't in place without some type of custody order. And Your Honor, there's no reason why these parties can't share joint legal custody of their two children. So I would argue that the situation at hand warrants some type of custody determination when it comes to decision-making regarding the minor children and also keeping the children in Michigan. This was a case where the police had to get involved, and it was not a good situation to get the kids. Miss Lewis was hours away from getting on a plane and going to Arizona. So I just don't want to see the same situation happen as it has. I have a case right now where there's a felony warrant out now because one parent took off with the children because there were no orders. So I am asking the court to word the parties joint legal, reserve parenting time, and keep in the order that the children can't be removed from the state of Michigan without the court's permission.
Thank you, Ms. Kuhn. Obviously, this court has jurisdiction over these children right now, and certainly the court would continue the prior order that neither party shall remove. Obviously, the prior order was that the mother shall not remove the children from the state of Michigan, but the court would order that that be both ways. Neither party shall remove the children from the state of Michigan. Any objection to that, Mr. Goldman? Does the court reiterating that neither party shall remove the children from the state of Michigan?
I do, Your Honor, just because I think that there doesn't need to be any custody order issued at this moment. The parties are currently residing together. I think it's abnormal to have a custody order in that situation. I don't know what's going to happen in a month or two. I know that Miss Lewis has no plans to leave. It's news to me that things are not going well. I think the parties are actively working on reconciliation. And if something needs to be filed in a month or two, so be it. But I think it's premature at this stage.
There's an action pending before this court. This court has jurisdiction over the children, so the court will order that neither party shall remove the children from the state of Michigan. And in case they separate this weekend, they should share, the court's going to order that they share joint legal custody. They share equally in major decisions concerning the welfare of the child. For example, if his child is taken to the emergency room this weekend, the other parent should have some say in terms of whether or not that emergency medical treatment is administered. And I don't see that's in the best interest of the children. So if you want, we can schedule a review date in 30 days if we need to address parenting time. But yes, parenting time is clearly premature, but the court will order that the parties have joint legal custody and that neither party shall remove the children from the state of Michigan. And at this point, do you want a review date in 6 weeks, Mr. Goldman, Ms. Kuhn? Or do you want to wait for for either party can re-notice it? But in the interim, neither party shall remove the children from the state of Michigan, and they shall share equally any major decision concerning the welfare of the children. They're 2 and 1 right now, so the only issue is medical treatment. And obviously, if the children are with dad, then dad should certainly make sure mom's aware that he's taking control of the emergency room, and vice versa. So that's the intent of the court. I believe that to be best for the children. The only question again: do you want a review date in 6 weeks, or do you want to simply notice it up if things change?
I can notice it up if things change, Your Honor. I don't know how long an eviction proceeding takes, so I can notice it up.
Let's try to be optimistic. Maybe the parties can sever or maintain and preserve the relationship for the benefit of the children, work things out between them. So at this point in time, the court will, we can note, Ms. Patrick, the parties are residing together, but the court will order joint legal. Neither party shall remove their children from the state of Michigan. Mr. Roman, anything further from your standpoint, your client's standpoint?
No, Your Honor.
All right, Ms. Patrick, you just add a couple of those provisions to this recommendation.
Your Honor, I will upload that into your queue.
Right. All right, anything further, Ms. Kuhn?
No, Your Honor, thank you.
All right, so the court would hope that the parties, for the benefit of these 2 children, 2 and 1 year old, can co-parent.
Hey, Ms. Kuhn?
I'll call you, Charles.
Okay.
We're hearing third parties. I'm not sure where we're picking up these third parties from. I'm hearing noises in the background.
I'm sorry, that's my children.
Go ahead
Okay.
and mute yourself, Charles, if you can.
All right. That will conclude, sir, and you can all zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
It's now in session, bottom of page 1, Cassandra Flores versus Jerry Jewell Jr.
For the record, this matter is before the court on the defendant father's objection to a referee recommended order that plaintiff wanted to be awarded sole legal and physical custody of the 12-year-old child. And this recommended order was issued as a result of the mother's petition to modify custody and parenting time. And the hearing this morning is being conducted via Zoom. It appears both parties are present. Cassandra Flores and as well as Jerry Jewell Jr. Good morning.
Morning, Your Honor.
The 2 of you have conferred with, good morning, Ms. Andrus. The 2 of you have conferred with Ms. Andrus this morning from the front of the court, who has provided the court fine recommendation. And the recommendation is that the referee recommended order be rescinded and canceled. And that a modified order entered that the parties shall share joint legal custody, which means both of you share equally a major decision concerning the welfare of the children, such as elective surgery and the like. The mother shall have physical custody, sole physical custody. Parenting time shall continue as previously ordered in the consent judgment of divorce, which was entered back in June of 2018. The court recalls the father had parenting time the first, second, fourth weekends of the month, Fridays at 6 to back to school and Monday mornings, and the entire summer parenting time. It's further recommended that the parties shall communicate via app close, which is an app that you need to download on your phone. The father shall not be blocked from the minor child's phone. And the minor child will continue counseling with Richard Polling. That is the recommendation. Mr. Jewell, do you understand the recommendation?
Yes, Your Honor.
If the court adopts this recommendation, it'll become an order of the court. Do you have any objection to the court adopting this recommendation?
No, I do not.
Ms. Flores, do you understand the recommendation?
Yes, I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
No, I do not, Your Honor.
Obviously, it's very important. I know, Mom, you live in the Dayton, Ohio area. Dad, do you live here in Monroe County? Or where do you live?
Yeah, I live in Newport, and she now lives in Temperance.
Oh,
Yes,
I moved back to.
Yes, I moved back to almost 3 years ago.
Wonderful.
We didn't go to the court. We didn't come to the court for it because Dad agreed that it was okay because obviously he was only like 20 minutes down the road from me. So it was best for the best interest of the child for us to be back in the same state.
All right. So, Ms. Flores, you need to update the front of the court in writing with your new address if you've not already done so.
Yes, I've done it now 3 times. So I did it when I first moved back to Michigan, and then they must have not have changed it because I would send it in through the mail. And then when I went to go file this motion, it was I had to change it again. So
all right.
I have changed it, Your Honor.
Okay. Ms. Anderson, does your office have the new Temperance address for Ms. Flores?
We should. Is it the Secor Road, Ms. Flores?
Correct. Yes.
Yes, we do have our
Okay.
updated.
All right, wonderful. So the part order was you're going to exchange in Rossford, Ohio. Where are you going to do the exchanges now?
Well, we've been doing it at the police station, pretty much the courthouse.
Yes, on 2nd Street in Monroe. Right by where you guys are.
Yeah, right where you are.
So it's between Newport and Temperance. Okay, what about the summer? I mean, obviously, the reason Dad got the extended summer was because of the long distance.
Well, yeah, so we just continued that as it was, and I just got him the whole summer, so I still have the time. But obviously, I would enjoy to have him another weekend now with them being closer. But obviously, we just never went to court because we just kind of continued the agreement we had.
Well, we need to make things clearer where we're going forward from this point.
So I mean, I'm willing to let you have them as what was before, like all summer, but the last 2 weeks of the summer, so I can get them on a sleep schedule again for school starting. Because that's how it was.
Yeah,
before.
and I had him 3 weekends instead of just 2 during the month.
So you have the 1st and the 3rd is what is in the court order from the divorce.
Okay.
Correct.
Hold on. The court stands corrected. The court's notes, your April 2018 divorce, judgment provided that fathers will have parenting time. Oh, yes, the 1st and 3rd weekends of the month, and then summer parenting time is a Friday that school lets out until the 2nd Sunday before school begins. So you're gonna go back to that schedule. Is that correct?
Yeah, we were just following the schedule from that.
Okay, because there was and this recommendation today clarifies that, because I thought I saw another order that said the 1st, 2nd, 4th weekends, but the judgment of divorce says the 1st and 3rd weekends. Fridays at 7 till Sunday at 7.
Prior to when she moved, I had 3 weekends instead of 2. But once she moved and it was such a long distance, they put me down to 2.
Okay, but at this point in time, going forward, you're going to go back to the provisions in the judgment of divorce, correct? Which is the 1st and 3rd weekends of the month. And
yeah, that's correct.
Summer beginning of Friday school lets out until the 2nd Sunday before school begins.
Correct.
And you'll meet. All right, wonderful. It's wonderful too that they're closer together. That will certainly benefit your son Jerry. Do either of you have any questions for the court?
I don't have any questions, but while we were in the waiting room, I already did sign up for the app close parenting, the co-parenting app, and sent Jerry the link to join me.
Okay, wonderful. There's enough challenges in life, so obviously make it good for each other and your son Jerry, and he'll do well in life. So it's wonderful. Thank you, Ms. Anders, for your assistance. The court defines any agreement between parents or investors to minor child. The court will currently adopt your agreement. You both mailed a copy of this. You can both zoom out. Have a good rest of the day.
Thank you, Your Honor.
All right. Thank you,
Thank
Your
you.
Honor. Have a great
Thank
day.
you.
Defendant.
Have a good day.
Thank you. Defendant father's objection to a referee recommended order of child support, which denied his request to modify tax-dependent exemptions provided for in the judgment of divorce. This matter is also before the court on the plaintiff's motion to enforce the judgment of divorce and for credit of direct child support payments. This hearing is being conducted via Zoom. Present is Attorney Gregory Calabrese, representing the plaintiff Dorian Carrizales. Ms. Carrizales is Mr. Carrizales is present, as is the defendant Jordan Carrizales. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Good morning, Ms. Mayville.
Morning, Your Honor.
Parties have conferred with Ms. Mayville from front of the court this morning, who has provided the court with a final recommendation. The plaintiff withdraws his request for enforcement of the judgment. Plaintiff agrees to file an amended tax return, which allows the defendant to claim minor child as a defendant for tax purposes for 2022. The defendant will file an amended tax return for 2023 and will cooperate with the IRS regarding any issues that may arise. Parties agree that the claimant who was awarded the child tax credit for that tax year will also claim the daycare costs credit as well that year. That is the recommendation. Ms. Mabel, do we also need a de novo order?
Yes, sir. That should be in your queue as well.
Oh, okay.
De
All
novo
right. So
queue.
we've got two orders. We've got this rec as well as a de novo order. Is that correct?
That
You
is
see
correct, sir.
Okay. All right. And the other de novo order is that the referee rank order be adopted but modified, namely noting that defendant withdraws her objections. So with this adopting this recommendation, the child support will be modified, correct?
That is
Yes, Your
correct.
Honor.
From $448 to, I believe, $525. All right. All right. Mr. Calabrese, good morning. Is your client agree with this recommendation this morning?
Yes, he is, Your Honor.
All right. Ms. Carrizales, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation?
No, not at this time.
All right. Anything further for the record, Mr. Calabrese? Do you wish to voir dire your client at all?
Just very briefly, Your Honor.
Okay, please.
Mr. Carrizales, you understand the agreement that has been reached here today,
I do.
and you don't have any questions about it, correct?
No.
I have nothing, Your Honor.
All right. Anything further, Ms. Jordan?
No, Your Honor.
All right. Good job, both of you. Thank you, Ms. Mabel, for assisting the parties and facilitating this resolution. The court will adopt the recommendation. Obviously, let's get those amended returns prepared and filed as soon as possible.
Yes. Thank you very much.
Getting forward, everyone knows who's going to claim what years, correct?
Yes, Your
Yes,
Honor.
we
Correct.
Okay. All right. That'll conclude this hearing. Never can zoom out. Have a good rest of the day.
Thank you, Your Honor. Thank you, Mr.
Thank you.
Honor.
too.
Welcome.
Thank you.
Camilleri.
For the record, this matter is before the court on the objections filed by the defendant Travis Camilleri to a front of the court parenting time recommendation of Catherine Scott. This hearing this morning is being conducted via Zoom. I'm present is Travis Camilleri as well as mother Karen Camilleri. Good morning, both of you.
Good
morning, Your Honor.
The two of you have conferred with Mr. Pratt from the front of the court this morning. Mr. Pratt has provided the court with a fine recommendation. Mr. Pratt, with this, we also need a de novo order or not? I guess it's not really a.
It's not a de novo, Your Honor. It's just the
Okay.
objection to the parenting time recommendation at
All
this.
right. Thank you. Okay, the recommendation, Mr. Camilleri, is that mother shall have overnight parenting time Mondays and Tuesdays. Father shall have overnight parenting time Wednesdays and Thursdays. The two of you will rotate weekends from Fridays until Monday mornings. The exchanges shall be at school or if there's no school, 8 a.m. It's noted that this recommended order, if adopted by the court, will address the complaint that's been filed. Mr. Camilleri, do you understand the recommendation?
I understand it, yes.
Do you have any objection to the court adopting the recommendation?
Yes, I still believe that we should keep the schedule as it is currently.
which is just different days of the week. You got Wednesdays and Thursdays overnight, correct?
Yes.
Okay.
I
Why
know.
did you?
She
Why
has
didn't you part?
she has the kids Monday through Thursday one week, and then Monday till Friday the next week, and then I have them on the weekends.
Okay. Why didn't you participate and return your parent time questionnaire to the front of the court?
I never received it, and then I missed the date for the meeting with her.
Why?
I was having medical issues. I was in the
I'm sorry?
hospital.
You're in the
I
hospital?
was in the hospital.
Well, when you got out, did you call Miss Scott and say I was in the hospital and I want to conduct
Yes, I
this?
went up there. I went up there to discuss it with her. She said since my day had passed, there was nothing that she could do. It was that one-time thing. So because that day I was in the hospital for kidney stones. I spent 3 or 4 days in the hospital.
All right.
Twice. I went.
All right.
Yeah, it was a long month.
All right. Okay. That's the court's question. Ms. Camilleri, do you understand the recommendation?
I do.
Do you have any? What's your position? Are you asking the court to adopt the recommendation?
No, I actually I was working every weekend and I switched it when Catherine Scott made that recommendation so that I could have every other weekend off to have my children. So I mean, my goal is to have them at least on the weekends too, so I can spend a whole day with them instead of a couple hours.
Well, this recommendation does rotate the weekends.
Yes.
Okay, but you're still opposed to it?
I'm not opposed to it.
Oh, I misunderstood you. I thought you were opposed to this recommendation. You're asking the court to adopt the recommendation. Is that correct?
Yes, Your Honor.
Right. Mr. Pratt, you've conferred with these parties for perhaps 20, 30 minutes this morning. Is that correct?
Yes, sir.
And obviously, you discussed their respective work schedules and their respective positions. Is that correct?
We did, Your Honor.
All right. What about summer parenting time? What about, would this continue throughout the year? Mr. Pratt, school as well summer?
Your Honor, there's no reason it can't. It's a 50-50. The only issue would be if one party wanted to take a vacation or something of that nature, we would probably want to build something like that in there. I believe Ms. Scott did address holidays in her original recommendation. I tried to discuss with the parties that communication would be extremely beneficial if they could communicate better than they do. But at this point, it seems reasonable to follow Ms. Scott's recommendation and allow them to do the 50-50.
Okay. All right. Ms. Montgomery, have you completed the SMILE program?
Yes, I have.
Okay. Mr. Camilleri, have you completed that? It's called SMILE, Start Making Livable for Everyone.
Yeah, a long time. I think that we did that during the divorce.
Okay. Well, it's a education to help you communicate. I mean, there's enough challenges in life. You need to work together on these issues and be flexible with each other. So what's your base for your objection, Mr. Camilleri, that this is not good for your schedule?
Mine?
Yes.
Okay. It's just it's what's easier for the kids right now. I mean, the new schedule will be a lot more back and forth between the kids. It'll be another extra exchange during the week. And also my other thing is her work schedule. I don't know anything about the new change in her work schedule. And I feel as if, like she said, it's a 2-2-3. So that means that she would have the kids 5 days out of the week. But my complaint with that would be is if she has to work one of them days and cannot be with the children anyways.
Okay, well,
if that makes sense.
Would you be home then? If she's off one day, are you going to be home to watch the children?
I'm home every day. I am disabled.
Okay.
So like the schedule right now with her, when she was previously working every weekend, she worked Friday, Saturday, and Sunday. So when she had the kids Monday through Thursday, she was home with them. The next week, when she has a Monday through Friday, her mom or dad, whoever was at the house, just is able to get the kids on the bus, which was fine. That was the only time that she would have been away from the kids, was that hour or two when the kids went to school. I feel like with this new schedule, one of them days she's going to have to be at work and not be there with the children for the full day.
Okay. Ms. Camilleri, is your schedule such that you know what day of the week that you will be at work?
So I will work every Wednesday and Thursday, which would be the days that he would have them. I go in at 7 o'clock in the morning. My mom would be able to put them on the bus in the morning for them to get to school that morning. And then I work every other weekend. So every other Saturday, Sunday.
So with this recommended schedule, you'll be with the children on Mondays and Tuesdays, as well as alternate weekends, correct?
Correct.
All right, Mr. Camilleri, that seems to address your concern that the children are not with mom because she's working. Court would agree if mom's working. And if she gets called in for another day, that's probably when you should reach out, Ms. Camilleri, to Dad and say, Dad, I've been called into work this week. This day was not expected, but you can have the children that day. Just makes sense.
Yes.
Like when to do that?
Yes, Your Honor.
Does that address your concern, Mr. Camilleri?
What I'm confused about is she says she works Wednesday and Thursday 1 week, and then the next weekend she works Saturday, Sunday. So she's only working 2 days a week. Is that my understanding?
Ms. Camilleri,
What she just stated?
Wednesday, do you work every Wednesday and Thursday, Ms. Camilleri?
Every Wednesday and Thursday and every other weekend.
Okay.
So 2 days a week.
Well, Saturday
And
is
alternating
considered
weekends.
1 week. Yeah. Sunday is a new week.
The court agrees it's a lot of back and forth for the children. The only other option is week on, week off, but then one of you is not going to see the children for an extended period of time. So this appears to be the most reasonable compromise, that the children are with dad when mom's working, and it's equal parenting time. So at this point in time, the court is going to adopt this recommendation. If in fact it's creating problems, Mr. Camilleri, you can always file a petition for the court to review it and modify it. But let's give this a try. Do you know what weekend you'll be working, Ms. Camilleri?
I will be off this weekend.
Okay, so you have the children this weekend. Today's, of course, is Wednesday. So the children are with you right now, Mr. Camilleri?
No, the children are with their mother right now.
Okay, I guess we'll start this next week then. Let's make sure we're on the same page. So the children will be with mom. When do the children come back to you?
Hold on. If she has this weekend off, that means that she was supposed to work today and tomorrow?
Correct. I took today and tomorrow off.
Okay.
So under this recommendation, the children will not be with dad until the next Wednesday. Is that correct?
Well, he would have them, I guess, today and tomorrow.
Okay. All right.
Technically,
Today's
if he
Wednesday.
wanted to.
How will the children go from school? Dad, were you going to pick them up from school?
Yes. For me,
Okay.
I pick them up and then take them to school since I live in Romulus.
Okay. All right. I don't know if they're expecting you today, but yes, we'll start this effective immediately. So dad will have today and tomorrow overnight. You'll take them to school Friday morning. Mom will bring back to school Monday morning. Dad again will have mom will have a Monday and Tuesday overnight. Dad Wednesday and Thursdays and alternate weekends. And the exchange will be at school unless there's no school. It'll be 8 a.m.
Can we change that to 10 a.m.?
Ms. Camilleri?
If they don't have school, instead of waking them up extra early,
That's fine.
let them get that little extra hour or two of sleep before I drive them back.
Okay, that's reasonable. Ms. LaPrade, could you kindly modify that to indicate 10 a.m., no school?
Yes, Your Honor.
Okay. All right, with that modification, Carl will adopt the recommendation, copy is mailed to both of you. If Mr. Camilleri, you think it's not in the best of his children, let's give it a try. You can always petition the court to review it. All right?
Okay.
All right, that concludes here. You can both zoom out. Thank you, Mr. Pratt.
Judge, we're going
Thank
to admit to a finding of contempt that Mrs. Kirk was ordered to pay child support. She did not pay in the amount that was ordered, and that it would have been possible for her to pay more than she did pay.
Right. Ms.
I
Kirk,
understand there's a recommendation from Ms. Hicks of 7 days with credit for the time she's already done, that she's already served.
all right. Ms. Hicks says, is it correct that the recommendation of 7 days, immediate credit for 7 days?
Not credit for 7, Your Honor, credit for 4 days. She has been in there for 4 days, so it would be 7 days immediate credit for 4 or $500 in lieu of the remaining 3 days.
Thank you. Ms. Kirk, did you hear all that?
Yes, sir.
Is your desire intent to admit to contempt this morning pursuant to that favorable sentence recommendation?
Yes, I'm not 100% sure what you mean. I don't understand certain things. I told you that yesterday.
Are you willing to admit to contempt that you failed to pay child support?
Yes.
Okay.
I understood that part. Yes,
The court is
sorry.
inclined to follow this recommendation of 45 days, 7 immediate credit for 4, which means you're going to serve 3 days in jail unless you can post a cash bond, which court will address. But you will have, after we're done here, you're sticking up 38 days hand to your head. So if you do not address this matter in the future, you could be you'd hold the key to the jail in the future. You understand that?
Yes, sir.
All right, Ms. Kirk, raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Okay, please state your name and current address for the record.
Brianna Kirk.
Thank you. Ms. Kirk, do you admit and acknowledge you're obligated to pay child support for the support and maintenance of children born to you and Kyle Buckley?
Yes, was that the same question from earlier?
Yes. Do you specifically
Okay,
admit and
yes.
acknowledge your outstanding arrears is about $1,900?
Yes, I understand.
Do you admit and acknowledge you have outstanding arrears of almost $2,000?
Yes, I know now.
Okay.
I do know now. Yeah, and I
Well,
can pay.
you should have known.
Sir,
Ms.
I
Kirk,
can pay.
Ms. Kirk,
I can.
Ms.
yes.
Kirk, do you admit and acknowledge you've not made any payments since March of 2023?
I mean, I admit it, but I didn't. I just
Okay,
didn't
that's what the
know.
court's asking. Do you admit and acknowledge you've not made any child support payments since March of 2023, almost a year ago?
Yes, sir.
Are you disabled?
Yes.
Okay, are you collecting disability?
I don't understand certain things. I don't know the
Are you-
word of it.
Okay, have you had any income in the past 12 months?
Yes, I get a check every single month. Like, if I would have known child support, I would have paid it, is my point.
Well, you now know you have a child support obligation, so you need to make regular periodic payments, Ms. Kirk.
Yes,
Ms.
I will.
Hicks, do you have any questions of Ms. Kirk?
I do not have any additional questions. Thank you, Your Honor.
Mr. Smith, do you have any questions of Ms. Kirk?
No, thank you.
All right, the court finds in this case that a support order does exist. Ms. Kirk acknowledges her obligation to pay child support. She further acknowledges that there are arrears of approximately $2,000. Ms. Kirk seems to suggest that she didn't know she had a child support obligation, which this court finds very difficult to accept. The court finds a lack of due diligence on the part of Ms. Kirk in not making any payments in over the past 12 months as a basis for contempt. This court will currently find Ms. Kirk in contempt of court. Mr. Smith, the court will follow the recommendation. In terms of jail, the court may consider reducing bond, however. Is there anything you want to say on behalf of Ms. Kirk before the court imposes sentence?
Judge, if you're considering reducing bond, I'd ask that you reduce it as low as you're willing to go. She does indicate that she can make payments, but she's having trouble getting a hold of somebody to make the payments for her from the jail.
Anything further, Ms. Hicks?
Your Honor, I believe that $500 is a reasonable amount to request. Yesterday, she stated on the record that she receives a check once a month in the amount of around $1,400 something, yet we've not received a payment since March of 2023. That is over 12 months ago that we have not received a payment from her at this time, with a case charging at $138 a month. $500 seems reasonable.
All right, thanks for reminding me. I forgot that she's received a monthly disability check of almost $1,400. Ms. Kirk, is there anything you want to say before the court imposes a sentence?
The whole time is I didn't get anything is my point. I didn't know. Like, I mean, I can't pay anything until my check or unless my brother helps me out, but I can't get a hold of them.
Ms. Hicks, the court has a hard time believing Ms. Kirk didn't know she had a child support obligation. What does your file reflect? Was she mailed notices?
Yes, Your Honor, everything has been mailed. And those payments that we were receiving in 2023 were coming from income withholding. So her paychecks were being garnished every single pay period to pay towards her support.
I used to work at Marco's, and after that, like, I quit, and then I didn't get anything after that. I swear on everything. I put that on everything.
Well, Ms. Kirk,
I was working there for over a year or so at Marco's, and that's why they took my money. So now I don't work anywhere. I just take care of my aunt and my mom.
Ms. Kirk, when money was coming out of your paycheck, pay child support, you should have known that you had a child support obligation, where that money was going to.
I thought it stopped because even before, I never even had a job until my sister got me in, which was just recently in the past like 2 years.
Right.
And I never had to pay child support. So I just,
Ms. Kirk,
I didn't
Ms. Kirk,
know.
a reasonable person would have made inquiry. If you noticed that if you're no longer working, but you were paying child support, you should have asked for the court, what happened to the obligation? Has it been removed by the court? You never received anything. So, Ms. Kirk, the court, you're not tell the court on that argument. In any event, the consensus court is you are to serve 45 days in North Carolina jail as follows: 7 days immediate. You're given credit for the 4 days you have served, which means you'll serve 3 additional days. We can be released today upon posting a $500 cash bond. Keep in mind, you got 38 days to have your head. If you don't pay not only current support, but some towards the verges every month, you're going to go back to jail. You've got 38 days to have your head. You hold the key to the jail, Ms. Kirk. So you decide whether you want to serve more time in jail or you're going to take care of his child support obligation. You're ordered to appear before Ms. Hicks for review. Ms. Hicks, what date do you suggest?
April 23rd at 10 a.m.
April 23rd, 10 a.m. Ms. Kirk, you need to appear before Ms. Hicks. And I will tell you, if you have not made payments between now and then, when you get your April disability payment, you need to make a payment in excess of $138 per month.
Okay,
if you're not making those payments, you're going to go back to jail on April 23rd. Do you have any questions?
No, sir. If I can't have any, if anyone can't help me, I can just pay like whatever on the 3rd, right? Or sometimes the 1st. It comes on the 1st. Is that okay?
Yeah,
I just
pay
come
it
here
when you get your money before you spend all that money. Your first obligation.
Yeah,
is
I
child
know. I'm
support.
not going to spend my money. Is what I'm trying to say. Is like I didn't know, you guys. I'm sorry. I didn't know. I would have paid it.
All right. So reach out to family and friends. If you can post a $500, then you can be out this afternoon. If not, you're going to serve the next 3 days in jail.
Okay.
A copy of this order will be faxed over to the jail. You'll get a copy when you're released to Ms. Kirk, and it remind you, and you also get one we mailed to you at your address. And you need to appear for Ms. 6, April 23rd, 10 a.m. If you don't appear on that date, another bench warrant will issue.
All right, sir.
So please pay attention to this obligation.
Yes, sir. I thank you.
All right, you can step out, ma'am. Thank you, Mr. Smith.
Thank you.
Thank you.
Now, session, top of page 3, Rachel Jorgensen versus Preston Bazell.
For the record, this matter is before the court in the defendant's motion to modify parenting time. This hearing is being conducted via Zoom. Present is Attorney Arthur Brand, representing the plaintiff mother. Mr. Jorgensen is present. In addition, Attorney Lawrence Neese is present, representing the defendant father, Preston Bazell. Mr. Bazell is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
The parties have conferred this afternoon with Ms. Brower from the front of the court, who has provided the court with the following recommendation. Namely, that the parties continue week on, week off parenting time with the exchanges on Sundays at 3 p.m. Mother shall facilitate and provide all transportation. Mother will drop off the minor child to the father at 4 p.m. Mother's week parenting time will commence Sunday, March 17th, 2024. Further, it's recommended the mother be granted permission to move to Osceola County, Michigan. That is a recommendation. Mr. Neese, you're the moving party. Is this recommendation agreeable with your client this afternoon?
Yes, it does, Your Honor. He conceded to allow her to change domicile. As long as she does all transportation, we are fine with the recommendation.
Thank you. Mr. Brand, is this recommendation agreeable with your client this afternoon?
No, it is not, Judge.
Okay. Well, first of all, there's no motion before the court to bring a change of domicile, so it's such a motion that needs to be filed, Mr. Brand.
I understand that, Judge.
And Ms. Dorson needs to understand she just can't, on her own, decide to move. So until that motion is heard by the court will address this. Okay, Mr. Brandt, what's your nature of your objections? What is your suggestion?
Okay. Well, the nature of my objection is the parties really have been honoring the week on, week off. And as I explained to Ms. Brower, since December the 21st, basically without getting into the semantics of it, each of the parties has had week on, week off. And it continued, for example, from January 29th to February the 4th. Mr. Bazell had the child, who's 1 year old today, by the way. And then my client got the child on February 4th. She would have returned the child on February the 11th, but for the fact that she found out that Mr. Bazell had been arrested. He was arrested in Westland, and he now stands charged with malicious destruction of property, which involved, we understand, a motor vehicle, and also domestic violence on his girlfriend. And she contacted me, and at that particular point in time, we had a discussion that was around February 12th and February 13th. And I told her she need to file the motion to change domicile, and which we have here. She signed it today, and the motion and a motion to suspend parenting time. Unfortunately, because she was in Everett, Michigan, which is 300 miles away, she wasn't able to get to my office to sign those two motions today. The motion to change domicile, the motion to suspend parenting time. And I explained that at our earlier meeting with Ms. Brower. Our position is clear that my client believes that because of the use of drugs and alcohol, this incident occurred. It's a serious incident, as I don't have to tell the court that, and it involves domestic violence. It involves damage to a motor vehicle, and as a result of that, his parenting time should be suspended. I'm sorry about the fact that it took my client this long to get here to sign that motion, but that's where we're at this particular point in time. The rest of it, I agree with.
Right, the court agrees, certainly serious charges, but did these incidences occur in the presence of the minor child, Mr. Brand?
No, because my client had the child at that time.
Okay, that's the court would be, obviously, the court would, without hesitation, adopt your position if, in fact, the domestic violence or these criminal offenses occurred in the presence of the minor child. Mr. Bazell obviously is presumed to be innocent. Now it's been alleged, now you indicated parties have been exercising week on, week off, but the plaintiff, or the defendant alleges that the plaintiff has not had any overnight since July of 2023. Is that untrue?
That is untrue, there, Judge.
Yeah, that's not exactly true, Your Honor. It's January 28th of this year. It's been approximately 1 month that he hasn't seen his child.
He had the child from January 29th to February the 4th.
And it's now March 6th, so about a month.
Okay.
And he is presumed innocent, Your Honor. He denies the allegations. He did not have the minor child with him in the presence of this incident. And she's been withholding the minor child. Mr. Brand and I had detailed conversations about this. She's had a month to file this motion if she really wanted to file a motion to suspend his parenting time. That's our position, is that the child should return today. And if they want to file a motion, then so be it, but they have not done so.
All right, so the child right now is in the possession of mother, is that correct?
That is correct.
And mother's denied parenting time since the 1st of January, is that correct?
No, it is not, Judge. Again,
February 4th, Your Honor.
February 4th to February 11th was her date. She did not, and that was the date that he was arrested. She's denied parenting time since February the 11th. That's the
Okay.
date.
All right. When did Miss Jorgensen move to Abarth?
I believe it was in November.
No, December 24th.
December 24th.
So since December, the parties have been exercising week on, week off, correct?
Yes.
And who's been doing the transportation?
I think they've been meeting where?
We've been meeting in Taylor, but we've been driving all the way here.
No, her plaintiff has. Your Honor, if I may, the recommendation became a final order on December 22nd, 2023. On Christmas Eve, my client learned that she moved.
I read the pleadings. Court's aware of that.
And he filed a motion immediately after that.
Correct. But since mom moved to Abarth, the party's still doing the week on, week off, and mom's been doing the bulk of the transportation. Is that correct?
That's
correct.
That's
Okay.
correct. And I might also indicate to the court, so the court knows, my client sent her own motion for a change of domicile to the court, but she received it back because she hadn't paid the $20 fee. The court should know that too.
Mr. Neese, does your client have an objection? I'm sorry, to the plaintiff's motion for change of domicile?
No, as long as she does all the transporting, Your Honor, he's fine with her moving there as long as she does all the transporting. He doesn't want to drive 3 hours to transport, to exchange the child. So as long as she's fully and solely responsible for all the transportation, he's okay with it.
Well, it's not unreasonable. Mr. Brand, Mr. Jorgensen's one that chose to move 3 hours away from the father of this child. So it appears to be reasonable that she should do the transportation unless they agree otherwise and meet halfway. But of course, not inclined to order dad to do that. Mom's the one that made the move. And knowing that this is not just an hour away, but 3 hours.
I've explained that to my client, Judge.
Right. Well, since Mr. Neese has no objection, the court will permit the change of domicile of the plaintiff mother to Osceola County. That's assuming that the motion will be filed, so we have something on file with the court. In anticipation of that motion, the court will grant the motion, be no objection, and the court will follow Ms. Sparrow's recommendation. The party shall continue the week on, week off parenting time, exchanges on Sundays. Mother shall provide all the transportation. Is the child down here in Lower Michigan today?
Yes.
All right, so she can deliver the child to father then at 4 o'clock in about 2 hours. And then
Yes,
the mother's week will commence on March 17th, a week from Sunday. Maybe things will change in the future. Maybe dad will move further north, but I understand that I'm not minimizing the seriousness of these criminal charges. If in fact Mr. Bazell becomes incarcerated or something, we can certainly take another look at the parenting time, Mr. Brandt. But again, he's presumably innocent and did not occur in the presence of a minor child. So the court's not going to be swayed just by the fact that these charges have been authorized. Is there anything further in this afternoon, Mr. Brandt or Mr. Neese?
Yes, Judge. My client believes that Mr. Bazell no longer has a cell phone, and she wants a number where she can communicate with him on a regular basis about their child when the child is with him.
Absolutely. Absolutely. Mr. Bazell, do you have a phone number that you can provide the mother of your child?
Yes, I've been contacting her off of the phone number 734.
Is that your phone?
It is my grandmother's phone in the house, yes.
Okay. Were you able to capture that phone number, Mr. Brand?
I got 73.
Yes.
Okay. So, Mr. Bazell, you need to keep that phone with you. I mean, obviously, Mom, each of you should be able to be in contact with each other regarding any issues or needs of this minor child. Obviously, when the child gets a little bit older, we can do FaceTime. And I mean, there's no reason why these parties cannot talk about each of them FaceTiming the child, even though the child perhaps is not going to converse, but at least be able to see the child for a short period of time during the time the child's in the possession of the other parent. And obviously, Ms. Jorgensen, Mr. Vizel, the two of you are going to have to talk, because when this child gets of school age, 6 years old, they're going to have another issue where the child's going to attend school. And the two of you are in the best position to make that decision. You don't want the court as a stranger making that decision of where your child's going to be educated. But that's an issue that can be addressed down the road. All right, anything further, Mr. Brand?
No, thank you, Judge.
All right, the court will adopt the recommendation as presented. And that will conclude this matter. Someone can zoom out. Have a good rest of the day.
Thank you. You as well, Your Honor.
Welcome. Thank you, Ms. Brower.
You're welcome, Your Honor.
For the record, this matter is before the court on the plaintiff's motion for to show cause, as well as the defendant's motion, emergency motion for sole legal custody, essentially modification of custody, as well as to suspend plaintiff mother's parenting time. This hearing is being conducted via Zoom. President is Attorney James Petrangelo, representing the plaintiff mother, Regina Smith. Ms. Smith is present. In addition, Attorney Teresa Olette is present, representing the defendant father, Shane Smith, and Mr. Smith is present with Mr. Olette. Good afternoon, everyone.
Good afternoon.
Good afternoon.
Before we begin, the court would note for the record that this court did enter an order to show cause on February 29th, directing the parties to comply with the order of this court regarding parenting time and for the defendant father to return the minor child to the mother and appear on this date. Within a couple of hours after signing that order, the court received an ex parte order from Attorney Olette on behalf of Mr. Smith, suspending mother's parenting time, but the court had already set this matter for hearing, so the court did not take any action on the defendant's request for an ex parte relief. Both having been received within hours of each other. Anyway, the parties have conferred with Ms. LaPrade this afternoon. Ms. LaPrade has recommended the current parenting time remain in full force and effect. The court recalls dad has parenting time every weekend, Friday 5 to Sunday at 5. Also noted that not only father, but also mother have violated the orders of this court regarding parenting time. There's no question the parties are taking things in their own hands. Mr. Pratt, have you received a copy of the defendant's response to the plaintiff's motion? There is attached to it a number of CPS law enforcement reports.
Yes, Your Honor.
Okay, the court went through all of those, and obviously there's concern, say to everyone, on protective services, law enforcement on the mother's conduct, making particularly, the court would agree, Mr. Petrangelo, these go, most of these date back to prior to the last order of this court of July 18th, 2023, but the court was sort of somewhat taken back by repeated unsubstantiated complaints of child abuse on the part made by Ms. Smith. The daughter of the parties that went through same exams within 3 months.
3 same
I don't know if we
exams
just
in a
set this
month and a
matter
half.
for a hearing. I just want to make sure the front of the court's aware of all that. Protective Services never sought to petition this court or file a complaint against Ms. Smith. Why, I don't know, with that kind of history. But the most recent complaint was made by a mother in January of 2024. And that report was made to West End Police Department as well as Protective Services. Does anyone know the status of the January 2024 incidents reports by mother?
To my knowledge, no formal action has been taken toward either party.
Okay, so it's still pending as far as you know, Mr. Petrangelo?
Well, I suppose it's a question. If no action is being taken, I don't know if anybody's acting on it. I've seen no reports of any recent activity from law enforcement.
Mr. Petrangelo, did you receive a copy of the defendant's response to your motion and all the attachments?
I did.
I didn't know if those were provided just to the court or if the other party received those, and Ms. LaPrade received those. Obviously, Ms. LaPrade, her office received those.
Yes, sir.
We received it.
All right.
And the court would note that mom filed a police report against dad as late as February 6th, claiming an occurrence occurred on February 3rd again, with again a false sexual allegation And according, we just received the report today, that again, Westland Police they're going to close the case because it's yet again another false allegation of sexual abuse against Dad.
Right. Mr. Petrangelo, is Ms. Smith still being assessed by a psychiatric nurse practitioner by the name of Patricia Tiemann? Do you know?
I know my client attends counseling. I'm not sure if that's something different. Ms. Smith, do you know who the judge is referring to?
She is retired. She retired a few months ago.
So are you still seeing her for any reason?
No, in October, I believe, of 22 is when I started getting on antidepressants with when I was seeing her, but I no longer see her.
That was a year and a half ago.
Yes.
Okay.
The reason the court's asking, thank you, Mr. Petrangelo, is the court believes that Ms. Smith should not to be evaluated. And she previously saw a psychiatric nurse practitioner, so somebody at that level that can do an assessment. Of course, somewhat shocked these allegations had come before the court prior. I know where the parties were back in this court in 2023, but the reports that Ms. Oletis provided the court those never came to the court's attention in the past. And court, if the court's going to follow this recommendation today, the court's going to add to it. The court wants a psychological evaluation of Ms. Smith.
Well, Your Honor, if you're going to order psychological evaluations, they should be done of each party. I would say, Your Honor, in this case, everything that's been raised with the except in the last few weeks is all related to prior to your last order. These the parties met with CPS. They haven't seen fit to take action against either. Their letter that I attached, dated February 15th, said the parties should follow the current parenting time order of this court. So CPS saw no emergency, saw no urgency. And what did my client do? She followed what CPS said. What did Mr. Smith do? Took the children, refused to return them, pulled them out of school, which is in the effect of telling the kids, don't you dare ever report anything I do, or I'll put you somewhere where you can't get any help. You have no counselor to talk to, no school authority, no parent. That's the scenario we're here. He held them. The only thing we have recently is she went to a doctor. The doctor said, report it. And I've attached the doctor's statement to that effect. She followed what the doctor said. When CPS said, follow the court order, she did. So she did exactly what was required except for 2 days. That's a proportionate response by her, does not indicate any psychological problem. What isn't proportionate is father with no emergency, because CPS didn't see any, refusing to follow what they said, refusing to follow what you said, pulling the kids away, pulling them out of school. I don't know what that has to do with anything except to keep them away from everybody. So it is, we've submitted photos to the friend of the court today and to counsel that show what appeared to be injuries. I can forward them to this court. I didn't want them in the court file. Red, purple circle on the child's anus, similar kind of injuries on the child's penis. It was a couple of days before she got into the Dr. Benjamin, but his recommendation was you are to go to the police. He made the report to CPS. That's the scenario. I don't see anything based upon that of any conduct in the last 8 months with these people for to suddenly say my client's acting psychologically inappropriately.
And Your Honor, I
Well,
just would
in court
like to
agreements,
point
the
out,
court has read the pleadings thoroughly from both sides. So I understand there's appropriate response by withholding the parenting time for weekend, but not a long period of time. Both parties are at fault, but clearly there's a history here, which this court was not aware of till just recently on the part of Ms. Smith. And the most recent was manifested in this another January 2024 report. I agree, most of these allegations go back to July of 2023. But the court was not aware of some of these allegations. There's numerous witnesses that indicate that these children are being coached by mother. The professionals have concerns about mother's relationship with the children. And the protection service is very slow to act, So it's not surprising that they have not taken the action. The court sees no reason for a psychological evaluation of Mr. Smith, but the court will order that be a psychological evaluation of Ms. Smith. I was hoping somebody, it doesn't have to be a physician, maybe a physician's assistant. Somebody that maybe, I don't know if Ms. Tiemann does any private practice. Does she do any private practice, Ms. Smith, or is she totally retired?
She's retired.
All right, maybe she can suggest someone to you. I'm really concerned about the continual. I mean, there's a pattern here. And back, yes, and I agree, Ms. Trenzl, a lot of these things are old. It doesn't provide the court for the basis right now to change custody or parenting time because they go back to prior to this order of July 18, 2023, which the court recalls the parties agreed to. Dad's parenting time was every weekend, Friday 5 to Sunday 5, but there's a history here that's quite disturbing to this court.
and Your Honor, I mean, she just filed in February another police report, and they didn't attach, ironically enough, the full medical record as to why the doctor referred mom to make another CPS report, and that's because of mom's history of what happened. Mom is the one who stated that there is a red anus with a possible tear, which has improved. Mom developed suspicion of injury when she overheard the child talking with his 6-year-old sister, whispering. Mother stated she heard daughter state the father threatened to hurt them and for them not to tell anyone. Mother further stated the daughter stated father tied patient to a chair by the ankles and has given him injections with needles.
Ms. Ouellette, the court has read all of that. You don't need to recite to the court. I said I've read every pleading, every piece of paper that's been submitted. I've read. The court notes for the record there are sexual assault complaints made by the plaintiff mother on October 2022, April of 2023, May of 2023, June of 2023, now again in January of 2024. So the court is inclined to adopt this recommendation. Parent time will continue. I'm going to set review dates, and then the court's going to order that Ms. Smith secure a psychological evaluation. And
so mother's
I think
parenting time
whoever's going to do that
continue?
evaluation needs to be provided with all these reports. So, Ms. Bertrandra, once she's identified a person that would do this, if you could inform Ms. Ouellette, the person who is going to do that evaluation, so Ms. Ouellette can transmit a copy of all these CPS reports and doctor's reports to that psychiatrist or the nurse practitioner psychiatrist. So they have the basis for this court's concern.
So can this be a psychologist or psychiatrist? You said psychological report. I wanted to be clear before I ever get somebody lined up.
Any thoughts, Mr. Pratt? Or again, I just know the reports that mother was previously was seeing a psychiatric nurse practitioner. So I think it's more of a psychiatric issue than a psychology issue. I'm looking for some suggestions, guidance, help.
Your Honor, I would think psychiatrist. It's been my history of knowledge that psychologists are more so medication when a patient needs medication. So if you want an actual diagnosis, you're probably going to want a psychiatric.
Okay. Ms. Ouellette, would you agree?
Yes, we would agree.
All right. So, Mr. Bertrandra, to answer your question via a psychiatric evaluation.
Your Honor, for the record, a week ago, the parties had a family meeting with CPS as well as Westland Police, and Attorney Ouellette was involved in that, which is part of the reason I made the recommendation I made. They did note, though, that mom needs to stop filing false allegations with CPS, so there has been involvement, Your Honor.
Okay. Is it possible they may seek authorization of a complaint against mother? Is that still open and pending?
That's what we were told by the Westland Police Department.
Okay, remains to be seen.
Furthermore, CPS has already indicated that they are formulating another case against mom for medical abuse as well as mental abuse of the children for having them undergo all of these sexual exams.
And if that comes to fruition, Ms. Olet, bring it to the court's attention. Again, the court's going to add to Ms. LaPrade, going to add your recommendation to your recommended order, Ms. LaPrade, that the plaintiff mother secure a psychiatric evaluation as soon as possible. And the court, like I said, this for review. I don't know how long it's going to take. Perhaps you can assist her, Mr. Petrangelo, in identifying such a person. I was hoping this Ms. Tillman was still available. Ms. Tiemann is Tieman. Patricia.
Perhaps we could I don't know if we can reach her anymore if she's retired, to see if she would recommend someone. There's a few psychiatrists here in the community.
Okay, so perhaps Ms. Smith can reach out to her, see whether she's got any recommendations, and if so, Ms. Smith, pass any names on to Mr. Petrangelo. Mr. Petrangelo, if you would notify Ms. Olet once you know the identity of this person, whether it's a psychiatrist or a nurse practitioner. I think that would be sufficient. And I'm going to court's going to send this for review.
I would anticipate it's going to take, just first we have to identify someone, then she has to make an appointment and all that. It's going to take a few months before we'd have any information for the court, I assume.
Okay. All right, we'll set a review date in May. Ms. Olet, if something comes to your attention about any charge being authorized against Ms. Smith, whether it's CPS or Westland Police Department, bring it to the court's attention. You can always notice this on, and we're pretty good at giving relatively quick hearing dates. So we'll set this for review and sometime in May.
Children go through again another sexual exam.
Well, yes, the court, I'm reluctant to order that this child not submit this minor daughter not to be submitted to another SANE exam, but Mr. Pratt, what's your thoughts on it? This child went through 3 SANE exams within, I believe, a period of 3 or 4 months. I mean, that's traumatic. And there's some comment that the doctor was concerned about her emotional well-being. But I'm reluctant as a court to simply prohibit the parties from securing such an exam. I would just strongly warn Ms. Smith, you better have some pretty strong documentation before you just submit your daughter to another sexual exam. It's very traumatic for a 6-year-old. Mr. Pratt, your thoughts on that?
Your Honor, I think that an order barring that would probably be contrary to what this court is attempting to do, but I would just strongly, I'm a firm believer in reminding people of fairy tales and the boy that cried wolf. So we just need to be cognizant that we're being honest when these things are happening, rather than and again, the police said no more false allegations, so it's brought to the police's attention, Your Honor. So if we could curtail that, maybe we could get back on track.
The problem is the kids keep undergoing these exams, and I feel there's no intervention.
Well, that's maybe CPS, push CPS. CPS is very slow to respond, Ms. Lett, and I understand that, but I think hopefully Ms. Smith heard the comments of Mr. Pratt. You better make sure that they're accurate and you're not making any false allegations, Ms. Smith, because that could result in a loss of custody if there's another occurrence. In any event, Mr. Petrangelo, Ms. Lett, do I have May 21st or May 22nd? And obviously, if Ms. Smith takes her to the hospital, Dad needs to be notified immediately, so Dad can go over to the hospital. You got joint legal custody. Ms. Smith, you need to immediately notify Dad on your way to the hospital before you arrive there that you're heading over there. If you take either of your children to the doctor or hospital, you need to notify Dad. Is that understood?
Yes.
And so Mr. Smith can respond immediately and be at the hospital, and he can provide input to the medical staff. So May 21st or May 22nd, Ms. Olet, Mr. Petrangelo, what works with your schedules?
What time on both those days, Your Honor?
We got the number of dates available, times available. On the 21st, we have 10 a.m. or 2:30. On the 22nd, we have 8:30 or 1:30.
The 10:30 date on the 21st would work, or The 1:30
That's
date
fine.
and the 22nd.
We'll take the earliest date because I don't want to see any more happen to these children. It's grotesque.
So what time is the 21st, Mr. Petrangelo?
I believe you said 10:30?
10 or 2:30? I'm sorry.
Oh, 10.
Latest
Well,
time.
either one on the 21st.
Okay. All right, 10 a.m. then. We'll put this
10 a.m.
review at May 21st, 10 a.m.
All right.
Mr. Smith had a question. I don't know if you want to see what his question is.
Is there, I mean, so mom gets unsupervised, unfettered parenting time, that's correct?
Correct.
And no makeup time for the time she missed at this point? Or is there?
Well, again, we can reserve that. Do you want to talk about that?
I at this point, I'm fine with reserving it. I guess after the court has more information after this evaluation.
Yeah, the court's probably not inclined to grant makeup parenting time, Mr. Petrangelo. Obviously, with Mr. Smith, yes, he should have petitioned the court, but he can't do that overnight. He acted out of trying to protect the children for another medical exam. So yeah, at this point in time, I'm not going to reserve that. The court's not going to give mother any makeup parenting time.
I would just, and I don't care if it has to be in an order, Your Honor, but this idea of pulling the kids out of school to, I don't see how that relates to anything that happened here that was appropriate. School issued a truancy notice. We just want to be sure nobody's going to do that again.
It was wholly appropriate because dad was withholding so that the children wouldn't have to continue to go through sexual exams. In fact, the school worked with dad.
That's a
The school worked
misrepresentation.
with dad. It is not a misrepresentation. We have lots of documentation. The school worked with dad to get the children out of school because mom was coming up there to pick them up. So the school is aware of what is going on with mom.
I don't know why the school would issue a truancy letter then, if that's the case, and which I attached. And certainly I mean, there was no rape exam or anything like that, no SANE exam in this. All that occurred before last July.
All right, it's all noted for the record. And obviously, what I understand is we have just a first grader, 6-year-old. So it's we're not in the middle of high school final exams or anything. So yes, the court agrees the child should be attending school, but I understand obviously if the child went to school, mom could have swooped up the children. Let's just move forward and review this matter on May 21st at 10 a.m. Ms. Smith, reach out to Ms. Tiemann and see if she can recommend an individual to the psychiatric evaluation so we can get that done. Let Mr. Petrangelo know the name of that person. All right. Anything further, Mr. Petrangelo or Mr. Olet?
No, Your Honor.
Okay, so what did the parties exchange for parenting time?
On Fridays.
Friday at 5.
Right, but where do they conduct the exchanges?
Oh, where? Where is it?
At a gas, it's a middle point at a gas station, I-275 Detroit Airport.
Okay, so that's been the exchange point in the past. So if so I want to make sure everyone's on the same page and they will continue to use that same exchange point.
Yes, sir.
So the children with mom right now, and mom will transport the children to the exchange point on Friday at 5 o'clock.
Yes, Your Honor.
Yes.
Right.
She
All
did
right,
that
so-
last weekend, just as the order provided.
Yes. All right. That will conclude this.
Page 2, Regina Smith versus James Smith.
For the record, this matter is before the court and the plaintiff. Defendant files motion to modify custody and suspend mother's parenting time. It's also before the court for the purpose of reviewing a psychiatric report of a plaintiff mother. This hearing is being conducted via Zoom. Present is Attorney James Petrangelo, representing the plaintiff mother, Regina Smith. Ms. Smith appears to be present. In addition, Attorney Teresa Olet is present, representing the defendant father, Shane Smith, and Mr. Smith is also present. Good morning, everyone.
Good morning.
Morning.
Good morning.
Just for the record, the court did review the non-public record of the court-ordered psychiatric evaluation of Ms. Smith. that's not part of the court file, but simply possession of the court. Of course, reviewed that. The parties have conferred with Ms. Pratt this morning from the front of the court. Ms. Pratt has provided the court with a fine recommendation that current parenting time order continue and remain in effect.
And Your Honor, if I may, that is.
One moment, please. Let me share
yes,
with you the
sir.
recommendation, then I'll hear from counsel.
Thank you.
Further, it's recommended the mother shall have a psychological evaluation from Wise Mind or another qualified provider on the list provided by attorney Kathleen Reed, who is a counsel for the psychiatrist who performed the psychiatric evaluation. Either attorney may submit materials to the evaluator for purposes of a full evaluation. The paternal grandmother must attend all appointments with mother and the minor children. Are the children to be involved in this evaluation?
No, sir. It's just for mom.
Okay. Obviously, so the recommendation, Ms. Pratt, about maternal grandmother being present for all medical appointments. Any medical appointments for the children, paternal grandmother will be present.
Correct.
All right, that's understood. All right, Mr. Petrangelo, is this recommendation good with your client this morning?
It is essentially, Your Honor. I think the only thing I would say, the language paternal grandmother must be present. We're fine with notifying and making arrangements for her to be present. We can't make her come. So I wouldn't want it to be interpreted that my client's done something wrong if she won't go. But otherwise, the concept we've already done that since we were here last, and that was something recommended by mental health. I can wait for counsel's statements. I did raise the issue of whether there comes to be a cost of this evaluation.
Okay. Well, what about, is there another third party that can be present if paternal grandmother is not available?
So far, she's been very willing to be available. I don't know that that's a problem, but that's who I believe CPS recommended long ago as part of a plan for these folks.
But let's assume she's not available. You suggested she may not be available, so let's come up with another third party that we can require their attendance in the event paternal grandmother is not available.
Shane, do you have another proposed third party that you would recommend?
Yes, I myself can be added to that list. Now, please understand that if I miss work, I don't get paid. But if it's something important, like, for example, my son has some type of mental health assessment coming up, I will absolutely be there for that. Obviously, if it's an emergency, I don't expect there to be a third party even in mind, because an emergency is an emergency. But to answer your question, yes, my mother's husband, who the kids call G-Pa, would be.
What's his name?
The only person that I would exclude from that list would be Regina's mother. Or Regina's sister, Benet.
Okay, I'm gonna have you talk with Ms. Pratt, and you can work through that issue, and I'll recall the case. I've got a very busy docket this morning. We'll put you back in the breakout room. Let's come up with a third party.
Just leave Robert. Is that okay, Shane?
Yes, ma'am.
Okay, can you spell the last name, please? Mr. Petrangelo, any objection?
Any objection, Ms. Smith? This is if grandmother can't be there.
I've never really spoken with Mr. Lerwick except for here and
put
there.
the breakout room.
So
okay, we put the breakout room. I've got other things to take care of this morning.
Get this covered. She is on, this is state insurance and state, she is on public assistance right now. The problem comes if there is a cost. You can't keep going to experts, and she doesn't have the resources. So if there's a cost, perhaps we have to circle back, or the court. I just want the court aware that's the part she can't just bankroll it.
And we would argue that moms caused this litigation. So if there is a cost associated, that cost should be paid by mom.
Well,
There's
she's
a
on public
legitimate
assistance, Miss
concern.
Olet. Pretty hard to order payment of some costs when someone's on public assistance.
She
So
was
I guess
able
we
to
can-
afford an attorney, Your Honor.
All right, I
Well,
guess we can
we
reserve
ask-
that issue, Mr. Petrangelo. Can reserve that issue. Now, I'm not sure who came up with this individual. This
Your Honor,
wise mind.
this was, counsel had a exchange with, the attorney for the psychiatrist. That attorney has provided the list, and said that a psychological evaluation would be needed to address the things Ms. Olet wants addressed. This isn't a question of, we certainly, we will comply. I assume the court would order it under that circumstance, so we're not arguing about doing it. It probably will be covered, but I don't know that. If you want to reserve that and have us renotice it on some kind of short notice, if the issue comes up, I'm fine with that too.
All right. Ms. Olet, would that resolve it if the court simply adds no census recommendation, the court reserves issue of costs if there is an out of uninsured expense?
Yeah, we can reserve that issue. I mean, I don't think we should argue if we don't know. So I'm okay with reserving that, but we do take issue with the parenting time remaining the same.
Okay.
We are arguing that parenting time should be supervised. If the court reads the psychiatric evaluation, mom's chief complaint is he told the children he was going to kill me. There is some legitimate concerns here with mom. CPS, if you've read through the CPS reports as well as the therapist reports of the children are not believing themselves. And that's an issue. She's a danger to the children with the constant accusations, with the constant taking to the doctor and these constant falsehoods that she's portraying by way of the children. So we are just asking until the psychological evaluation is complete that mom have supervised parenting time.
Your Honor, I had hoped not to rehash what was a heated issue in the other room, but the history here is mom was violently and feloniously attacked by Mr. Smith and convicted and put on 5 years probation. He's gone through mental health treatment. He has gone through inpatient alcohol treatment recently and relapsed. My client is afraid of him. She does have PTSD. Of course, she raised her history and her concerns with the psychiatrist. That it wouldn't do her much good if she didn't tell the psychiatrist about this background. I notice counsel didn't include any of that information in her motion about what leads us to today. So what has been stated by Mr. Smith and acknowledged that since we were here 10 weeks ago, things have gone a little better. And nothing's happened in this 10 weeks to now suddenly cause us to need supervised visitation when we didn't need it 10 weeks ago. My client's actually gone to get treatment. She's seeing somebody now on this sort of issue. She's agreeing to have a psychological evaluation. There was a doctor visit. She did contact and make arrangements for Mr. Smith's mother to go. He appreciated that that's in place. We're headed in a better direction, not a worse. So I don't think the request is warranted at this time.
And we would argue that mom's also been convicted of domestic violence against Mr. Smith. And the reason that we were brought here today was not because of Mr. Smith's past domestic violence that occurred well over 5-7 years ago. We're here because mom is falsely accusing dad of sexual abuse against the children, causing them to go through SANE exams and rape kids. And most important to note is, as of 4/1, the date of her psychiatric evaluation, it wasn't a history that was given. Her chief complaint. So that is something actively that she's going to be evaluated for, was he told the children he was going to kill me.
I would just tell the court that counsel provided me her exchange with the attorney for the psychiatrist. And I would tell you that my client tried to get just an evaluation for the court. She had trouble finding anyone unless it included also addressing treatment for her. And the attorney says, the intake report staff states she was seeking both an evaluation for parenting court and behavioral health treatment services. So she very clearly at the offset told them why she was here, that this was part of it. We made sure counsel was given the name of the person. Counsel submitted documentation. Counsel doesn't like it that the doctor said ignored it. But we can't tell these experts what they have to decide is most important. My client went, she was honest, she disclosed, she told them exactly what the issues were. She's doing what she should do. She shouldn't be attacked for that.
And he's arguing the issue of the need for a psychological evaluation, which we've already surpassed. What is concerning is mom's current and still belief that the children are telling her things that dad is allegedly doing that is not the case. And that's what's concerning. The children's own therapists, if you read through the CPS reports, say that the children aren't believing themselves because of mom's coaching. So mom is a danger to the children. I still believe that mom is a danger. Have things gotten better? I can acknowledge that they have, to some extent, only because paternal grandmother is involved in the doctor's appointments. However, as early as Thursday of last week, less than a week ago, mom again sends an accusatory text message to dad asking, what's this bruise on the minor child? And this is how it just gets ramped up and started every time.
I would only say she's trying to put my client in an impossible situation. She sees something, she asked, she got a response. Nothing further came of it. There was no CPS complaint report. Is she want to create a situation where if there's an injury, my client can't ask? Of course she can ask. She handled it properly. There's nothing, none of the things being brought up have happened in the last 10 weeks. And we dispute that much of any of this has happened recently. But in any regard, it wasn't necessary then. No harm has come because we didn't put supervised parenting time in place 10 weeks ago. If anything, it's gotten better. So what is the justification to now go back to this unless we're going to have some kind of hearing to demonstrate some increased harm to the children or danger?
May I speak?
Right. It's not necessarily Mr. Smith. The court's heard enough. You can speak with your attorney after we're done here. The court will rely upon the recommendation of Ms. Pratt. She has conferred at length with the parties this morning. A recommendation that current parenting time remain in effect. The court is not convinced that supervised parenting time is necessary at this point in time. The court would simply add another note that it's unfortunate that Ms. Smith did not advise this Dr. Cushman, who did the psychiatric evaluation, of what prompted us. It was all here because of the numerous complaints of sexual assaults by dad and the children being taken for sexual examinations unnecessarily, when in fact there's no basis for some of the allegations. That information needs to be provided to the psychologist. So what this recommendation today is that both the council can provide the materials to that evaluator. That's essential. It's unfortunate Dr. Cushman did not have that information. That's
Dr.
clearly missing
Cushman
from her
did.
evaluation.
I'm sorry, Your Honor. Dr. Cushman did have the evaluation. That is what prompted Attorney Reed to reach out to me because I was told by Dr. Cushman's office that Dr. Cushman would not be given the materials because she does not have to review them. I said, well, sure she does. And the court has instructed that I can submit materials for her review. And that's when Attorney Reed said that this doctor cannot perform an evaluation for custody and parenting time. That would be inappropriate, and we would have to go with a psychological examination.
All right, so hopefully we'll have a better insight with the psychological evaluation. So the court will adopt the recommendation. Mr. Pratt, if you could simply add that the court will reserve the issue of addressing any out-of-pocket expenses associated with that.
Yes, sir.
This obviously is for the benefit of the children, this evaluation. So if in fact Mr. Smith has to contribute toward that, then so be it, but we'll address that at a later date if it's necessary. All right, anything further then this afternoon, this morning, Mr. Petrangelo or Ms. Olet? I know Mr. Smith wanted to talk. Do you want to talk with Mr. Smith? Ms. Olet, we can put you in a breakout room separate.
No, you're.
No. Okay, he's okay.
Okay.
Thank you.
All right, the court will adopt the recommendation. And do we need to set a review date on this? Or is somebody going to renotice it?
I think we need a review date for the psychological evaluation.
Do you have any idea of the time frame?
Your Honor, I'd request the court gave us 10 weeks. And I think, you're trying to get scheduled, get in, get a report and so forth. I'd ask about for that same time frame.
Ms. Olet, would you agree?
I would agree.
Okay, so 10 weeks. So we're looking at July 23rd, 8:30. Would that work with everyone?
That would work for me, Your Honor. Would that work for you, Shane?
Yes.
That will work.
All right, Mr. Pratt, could add that the review July 23rd, 8:30, please.
Yes, sir.
With that, we'll adjourn this matter to that date, July 23rd, 8:30.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Pratt.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.